A revocable or living trust avoids probate. And the reason why is because the trust owns title or holds title to the assets that cause probate, like your bank accounts and your house, investment accounts, things that have title, that are titled in your name or in the trust name, are in the trust. So instead of having to go to probate to get those things transferred or distributed according to your wishes, the trust says, my successor trustee, who is the person that's in charge after you've passed away, which is basically that executor, my successor trustee has the ability to transfer and administer my assets according to the terms of my trust. And they're authorized and given the authority pursuant to the terms of the trust to do that.
You are listening to the Legacy Talk podcast hosted by James A. Jones,
attorney at law and founder of Sound Legacy Law, PLLC in Tacoma.
Attorney Jones is here to talk about how to best protect your family, assets, and wealth, pulling stories from his more than 20 years of helping families and business owners protect their assets, create their estate plans, preserve their wealth, and plan for the future. Nobody wants to think about estate planning, but life has a way of sneaking up on you, and at any moment, something unexpected could happen that will leave you regretting not having acted sooner. So join Attorney James A. Jones in the Legacy Talk podcast, and together learn how to plan for your future today and have peace of mind tomorrow.
Welcome to the Legacy Talk podcast. I'm your host, James Jones. I'm an estate planning attorney and probate attorney in Tacoma, Washington. I've been practicing law for about 20 years, and like I said, my main focus is estate planning, probate, and estate administration. On Legacy Talk, we talk about topics surrounding families and estates. Estate planning is often a confusing and complicated topic, but my goal with this podcast is to make it understandable and accessible to those that need it. So if this is something that interests you, I'd appreciate it if you check the subscribe button and like this episode so that you can follow along with us as we break down the barriers of estate planning. I'm excited to get to today's topic. So today we're talking about the great debate, a will, a trust, or both. Making the right choice for your estate plan, so that you know what type of estate plan you need to protect your family's assets and legacies. So on today's show, we're talking about the great debate, like I said, a will, a trust, or both, making the right choice for your estate plan. So let's get right into it. So if you're listening to this podcast, you might have wondered which type of an estate plan is right for you. Should I do a will-based plan or should I do a trust-based plan? And typically that trust is a revocable trust or a living trust, which you've probably heard about, which we'll talk about today. We're going to discuss 6 factors to consider in deciding what type of an estate plan you should have. Both wills and trusts have their advantages and purposes, and they meet the needs of people in varying situations, but it is an important decision to make sure that you have a plan that makes the most sense for you. We're going to talk about 10 factors that you should consider in deciding between a will or a trust as the central component of your estate plan. So what are these 10 factors, okay? So factor 1 is probate avoidance. So probate, we'll talk about on another episode in more detail, but essentially probate is the process of clearing title to assets when someone passes away. It's a process that takes place in a court with a judge, and that process typically takes 6 to 12 months on average. And the purpose of the process is to clear title for someone that hasn't got the ability to sign anymore because they've passed away. They're no longer with us to sign. And so probate is often that bugaboo. We want to avoid probate, and a lot of the time I agree with most people when they say that. With a will, you would go through probate. It's a common misconception that a will avoids probate. A will does not avoid probate. And the reason why we have to go through probate is because with a will, or even if you don't have a will, but in this scenario, we're talking about a will, the will nominates an executor, and that person is nominated in the will, but not authorized. And so the court has to get involved to authorize or give that person authority to be able to administer the assets of the estate. And so that's why we have to go through probate. With a trust or revocable trust, which is what we're talking about today, a revocable or living trust avoids probate. And the reason why is because the trust owns title or holds title to the assets that cause probate, like your bank accounts and your house, investment accounts, things that have title that are titled in your name or in the trust name are in the trust. Okay. So instead of having to go to probate to get those things transferred or distributed according to your wishes, the trust says, my successor trustee, who is the person that's in charge after you've passed away, which is basically that executor, my successor trustee has the ability to transfer and administer my assets according to the terms of my trust. And they're authorized and given the authority pursuant to the terms of the trust to do that. And so that makes for a quicker distribution. It makes for cheaper lawyer fees typically, not having to go through a full-blown probate, and it makes it faster and simpler. And so if we're keeping score, I guess, if you wanted to keep score on this, avoiding probate is your main goal, then a trust is for you. Okay, versus a will. Now, factor 2 is privacy. And so with a will, this comes back to the probate process. With a will and probate, that is a public record. It's with the Superior Court in Washington, if you live in Washington. And Superior Court records are public records. So anybody can go and look at the case and look at what the assets are, what's on the inventory. What did John have next door? The nosy neighbor comes and looks. So that's all public. And so all that stuff gets filed with the court. And so with a revocable trust, because you're not going through probate, the nosy neighbor is not coming to find out how much money you had or what assets you had. Your asset distribution to your kids, grandkids, charities is private. It doesn't get released publicly. And so if you want to have your sensitive information, not that they put account numbers or anything on anything, I'm not going to say that, right? But if you want to have your personal affairs private, you don't want to go through probate. You want to go and have a trust as your main distributor. So if we're taking score, this is 2 points for trust, 0 for will, I guess, if we're taking score on this thing. I'm not saying that wills are bad yet. So we'll see. We'll see. See what it takes us as we keep going on this. So factor 3, complexity. So a will is simpler than a trust. Okay. It's more of a simple process as far as getting a will set up. And after the fact, having a will doesn't require a lot of legwork. So when you create a will, you basically say, hey, I want to do this and I want my stuff to go with these people and I want to have this person in charge. And you sign the document, you're done. You don't have to change title to assets. You don't have to move your house around or bank accounts or anything like that. That is not true for trust. Because with the trust, the reason that we avoid probate with a trust is because the assets that cause probate, like we mentioned, like your house and your bank account and your investments and things like that, are already owned in the name of the trust. Okay. So how do we get them in there? Is we retitle things. We have to transfer your house into the trust via deed. We transfer bank accounts, retitle them into your trust. We retitle your investment accounts that are qualified to be in a trust. And so there's a little bit of legwork involved to have a trust to get it funded after you've set it up. So whereas with a will, you sign it and you're done. With a trust, you sign it and then you get started with work. For my client, I help them get all that stuff transferred. That's not always the case, and there's a little bit of legwork, but usually it's worth it to have that extra legwork. But in the short term, it is a little bit more complicated to set up a trust. So that's the third factor. I guess we can call that a will. If we're looking for a simple plan, the will maybe wins. So we're 2-1. So factor 4, incapacity planning. So we don't think about this very often, but what happens if we can't make a decision but we're still alive? I think we talked about durable powers of attorney on a previous episode and how important those are as far as allowing someone to help make financial and medical decisions for you. But another thing that helps with that process is a revocable trust. Revocable trust can include provisions and typically include provisions that allow for the trustee or the successor trustee in this case. If you become disabled, the successor trustee can come in and help make financial decisions of the assets in the trust. And so what that does is it avoids things like conservatorships where a court gets involved for someone to help manage your assets. And it just makes the transition so much smoother if you're not able to make a decision due to incapacity. Wills don't have that. So wills are very simple documents essentially. They don't have provisions that say, well, my executor can take over if I'm not able to, because in a will, that executor doesn't have any authority until he goes to court or he or she goes to court and gets that from the judge. Okay. And so if a will is required to be used to get authority to manage assets or affairs of someone, it's called a guardianship or conservatorship. So we don't want that. Let's avoid that if we can. Okay. It's one of the reasons we do estate planning is we can avoid things like guardianships and conservatorships. So incapacity planning, we've got to win for the trust on that, I think. So 3-1 trust versus will for now. The fifth factor to consider is control. So this goes a little bit both ways because you can control the distribution of your assets at the time you pass away, the same way essentially with a will or a trust, okay, as your base document. So revocable trust says, I want all my stuff to go to my best friend Bob. That's where it's going to go. If my will says I want all my stuff to go to my best friend Bob, that's what happens, okay? So as far as that's concerned, where things go can be determined the same way with the will or trust. Process of administration is different, okay? Trusts are important though for people like minor children or people with special needs. As far as distributing and controlling where things go, a will can create a trust or a revocable trust can create a trust, okay? And so I think it's probably a wash on that one. I think that's probably a tie because as far as getting things to people you want to get them to, you can do that in a will or a trust, and you can put those things in more controlled environments like a special needs trust or a minors trust or dynasty trust from a will or a trust, just the same. The process of getting it from the main trust or the will to the new trust is different because you go through that probate process. But I think as far as control goes, I think we'll call that a tie. Okay. So we're 3-1-1. I guess if we're keeping score. Okay. Factor 6, cost. It costs more to do a trust or a revocable trust plan than a will plan up front. Okay. So a will plan is going to be a little bit cheaper to do. In my office, it's probably a third to a half less expensive than a trust plan. And so if money is the barrier to entry on either one of these plans, the will is easier to get into. And the reason why is the trust has intrinsic value because it skips probate. It makes the administration easier in the back end. So you're getting more value with the trust than you're getting with the will. That's why a will is cheaper than a trust. So when you're weighing whether you want to do one or the other, the will is going to be the simpler, cheaper thing to do, at least up front. But if you want to also consider costs of administration, I tend to think that a will is more expensive of a plan. And the reason why is because you got to go through probate later. And probate's not cheap because typically you got to hire a lawyer to do probate. And I charge about $2 or $3 or $4 or $5,000 more to do a probate than I'd charge to do a trust. So it's a lot more work. It takes a lot more time. So it's a more expensive process. So typically the trusts in the long run is cheaper. The will in the long run might be more expensive because you're paying for the will and then you're doing probate. So if we're keeping score on this, maybe we give this a half. Yeah. Maybe we give it a half. So will gets the cost benefit for inception, right? When you're setting that thing up, it's cheaper. With a trust, you're getting a long haul discount probably. Over the long haul, you're probably paying less for the trust than you are for that will plan. So let's call it a half. So we're 3.5 and 1.5. I guess if we're keeping score, one tie. Factor 7, time sensitivity. So there's a lot of legwork in trust. We've talked about that, right? With a will, you sign it and you're done. So if you need something quick and I don't want to I don't have time to fund this thing, I've got to do it quick. And this comes into play for people that are in failing health, rapidly failing health, that are able to still sign documents. And we just don't have time to get things funded properly. Or it's people that are going on vacation, like, oh, we haven't updated our will in 15 years and we're going on vacation in a week. And we've got 3 kids now. Those people, we probably do a quick will. And when they come back, we probably revise it, maybe make it a trust. And so if you're looking for time sensitive, I got to get this quick, and you want to avoid full probate, because you can do a trust fast too. We could draft the trust about as fast as we could draft a will plan. But the benefit of the trust as far as a probate avoidance is probably not going to be attained fully, because you don't have time to get the assets that cause probate transfer. Like, those bank accounts can be pesky. Those financial accounts can be pesky. Typically, the real estate's pretty easy. But so if we're talking time sensitivity, we got to go on vacation or someone's passing soon. We don't have time to risk it. A will might be the plan. Okay. So the will's the simple stopgap in many cases like that. So we'll give that one to will. So we got 3.5 to 2.5 from one tie. Okay. We'll see what happens at the end of this thing. So factor 8, property location. So you may have a question about this, right? I've got a house in Washington. Many of my clients have houses in Washington. Majority of my clients have houses here, because most people that do an estate plan have a house that they live in. A lot of them also have a house in Arizona, or a condo in Arizona, or a house in Idaho, or a house in Oregon or Montana. And so if we have houses in more than one jurisdiction, more than one state, it's better to have a trust. And you're asking, well, why does that make sense? Well, because if you had a house in Washington and you've also got that condo down in Arizona, if something happens to you, if you pass away and you have a will, you're going to do a probate in Washington and you're going to do a probate in Arizona to transfer title to that house in Arizona or a condo in Arizona. And so with a trust, that condo in Arizona is in the trust just like the house in Washington. So you're avoiding probate here in Washington, and you're also avoiding probate in that other state, which could be completely foreign as far as your kids are concerned or whoever's in charge of your estates. So chalk one up for the trust on that one. Okay, that's a simple one. If we want to avoid probate in multiple states, a trust is the answer. 4.5 to 2.5 plus one time. So we'll see where we go. We're getting there. Factor 9, asset protection. So this is beyond the scope really of today's topic, but I wanted to mention it. The revocable trust that we're talking about today, the revocable living trust that most people do, if they have a trust, they have a revocable living trust. 90% of the time, probably 99% of the time. And that trust is not an asset protection trust. A revocable trust, because it's revocable and amendable, and you have full control as the grantor setting it up, and you've got full control as trustee running that thing, that trust is basically your alter ego, right? When I talk to clients, and you might hear this too, like corporations or limited liability companies, those kinds of entities are designed to not be someone's alter ego. They want to be completely separate, right? Separate bank accounts, separate tax ID number, all those kinds of things, formalities that you have to follow. With a revocable trust, it's you on paper. Even though there's bank accounts involved, those bank accounts are established under your personal social security number. There is not typically a tax ID number separate for that revocable trust during your lifetime. As far as asset protection goes, the revocable trust versus the will, there's really neither of those provides any asset protection other than potential privacy with a revocable trust. And keeping, if you use I guess there's a scenario where a revocable trust might lend itself to asset protection or more privacy in an asset protection standpoint, which would be if you used a fictitious name for the trust. And that might make it a little bit more difficult for judgment creditors or somebody to see if you have a real piece of real estate or something. But if they found it, it doesn't protect the real estate. So if they find it, it's not protecting it. So neither one wins on that, I guess. The will doesn't provide any asset protection either because it's not changing title or anything. It's not providing anything different as far as it's just you. It's you, it's you, it's you if you have a will. So I don't know how to score that one. Maybe we say not applicable, no score. Okay, on that. I'm writing this down so we can get this right at the end. Factor 10. This is the final factor. Beneficiary needs. So this might be a tie as well. We'll see. Everybody has different issues, right? Every family is different. And we talked a little bit about this with the previous factor of control. Okay. It's a similar discussion here. With a revocable living trust and will, both of those distribute assets the same way as far as this guy gets this guy gets that. They don't differentiate as far as how things are distributed, right? A will can create a trust just like a revocable trust can create a different trust. So if we're looking for special needs planning, or if we want to make sure that we're protecting our kids' inheritance, we can do that in a trust, a revocable trust plan, or a will plan. So in reality, the beneficiary needs doesn't matter whether you do a will or a trust. You can do that kind of planning in a will or a trust. So if you had a special needs child, we would want to create a special needs trust, but you might not have significant assets. So maybe we put that trust in a will that's created when you pass away. Because the only reason you're creating that plan is because you want to make sure that any money that would go to your special needs child is in a special needs trust. And that might not require probate. So that might be the reasoning. But I think every plan, right? Everybody's plan is different. I think we probably call that a wash too. Maybe we're tying on that one too, because we can do both in the trust versus the will, as far as setting up your plan specific for your beneficiaries. So where did we end up on this thing? So we're 5 for the trust because we had 2 halves. We had 4 and we had 2 halves. That's 5, right? And we got 3 on the will side. So if we're keeping score, 5, 3, and we have 1 tie. So 5.5 versus 3.5, I guess we're going to say, with 1 that was no contest, not applicable. So I guess if we're keeping score, do a trust, right? I want to be on the winning side, trust. I guess if we're going to call it that. But like I said, everybody's needs are different. Certain situations are better for wills versus trusts. And in reality, like, I'll give you this story, right? So every podcast, I try to put something real world, client related story, okay, to illustrate the point that we're talking about. So story for this episode. So I've been practicing about 20 years, 21 years, and I've had clients for 20 years. And so over that time, I've seen clients come in and their families grow, young families grow into middle-aged families, or middle-aged families grow into elderly families. So this story is about the Appletons. When I first met the Appletons, they were a young married couple. They had a daughter who was under 1 year old. She was 6 months or 9 months old. So they were proactive. They came pretty much right after they had that baby. They were starting out in life. They were young marrieds. They didn't have a lot of assets, just starting new in the career and stuff like that. Their issue was that they needed to name a guardian for their daughter, and they needed to create a mechanism to manage her estate. So if they passed away and she was not an adult, as you may not know, minor children cannot hold assets in their name. That's why your name is on your kid's bank account, right? Until they're 18. Or even after they're 18, in my case, they're still on there. So their issue was they needed to name this guardian. They needed to create a trust for their minor daughter. So in their scenario, this first time I met with them, the plan that made sense, because they had lower assets, but they needed to take care of their daughter, was a will. Because with the will, we can create a minor's trust that would hold that money until she was old enough to manage it herself. Typically, a minor's trust will distribute those funds at a certain period of time once the child's an adult. So sometimes people put it in phases. Sometimes it's, well, when the kid's 25, they can get it all. Sometimes it's younger, sometimes it's older. But the money's in there for college and living expenses and all those things. That child is protected and has resources. So the will was their plan. That was it. So the first plan I did with them, we did this will, we did power of attorney, we did healthcare directive, because every plan that I do, we want to do a healthcare directive, we want to do a durable power of attorney. So that's where they were. So fast forward 6 years. The Appletons came in to see me with 2 more daughters added to the fray, 2.5 and 6 months. So they had a 6-year-old, a 2.5-year-old, and a 6-month-old. And they've been good stewards with their estate. They've saved their money. They bought a house, they had a piece of real estate. And so their house and their assets were more substantial. And so we talked about the pros and cons of will versus a trust, and they decided to change to the trust plan. And the reasoning mainly was, we can have this trust and it's going to solve most of our problems for the rest of our life. And because their estate was a little more complicated, and in Washington state, we have an estate tax, and they were on the verge of being over that exemption level, which right now is 2.193 million, which isn't very, very high with our real estate prices. And if you've saved money and retirement and all that stuff. So they were button up against that. So most of my tax planning I do through a trust. I don't typically do it through a will, because why would I go through probate if I'm dealing with an estate tax like that? If I have enough money to pay estate tax, let's pay little bit more money and do a trust. So the trust at that point was the better choice, and they switched. So we got the tax planning in there, and we got the added benefit of probate avoidance. And we got the added benefit of having individual trusts for their kids that would become lifetime trusts rather than minors trusts. So that basically means that the trust at a certain age, instead of distributing it to the child directly in their own name, it allows the child to, as an adult, take control of the trust as trustee at 25 or 35 or 45 or whatever age, and keep those assets protected from creditors and divorce and car accidents and all that kind of stuff. So they picked that and went with that. So that was their second meeting, their second plan. 4 years later, I met with the Appletons again. And at this point, they had added one more daughter to the total of 4 kids now, 4 daughters. And because their trust was easily amendable and simple, they added their new daughter and rearranged a few of the choices for guardians on their will and beneficiaries and trustees on the trust for the kids. So, like I mentioned before, that trust should serve them well for the rest of their life without major revision. Unless there's a major law change, it should be good. So with that trust, they avoid probate, they avoid estate taxes potentially. They protect their kids' inheritance, and they can amend it and change it anytime they want. So in this example of the Appletons, at certain times of their life, a will was the best plan, and at certain times of their life, the revocable trust was their best plan. And so over a period of 10 years, they switched, right? And so now as their kids are turning into adults, they'll probably end up making more changes, because typically people have their kids be in charge of their stuff if they're responsible kids or as adults. I always call them kids. They're adults at this point, but they're kids to you, right? 4 of my kids are adults. I still think they're kids. So that trust served them well, and that trust structure is going to stay the same. One more little tip about the will versus trust, and maybe we give a point to the will on this, is when you do have minor children, and I didn't put this in the list, but in that story, the Appletons had a minor daughter. They had 4 minor daughters at one point, and they needed to appoint a guardian who would help manage their affairs and take them to the doctor and make sure they go to school and all those things, right? If they're minors when their parents died. In order to name a guardian or nominate a guardian, that's done through a will. That's not done through a trust. So maybe we say, well, if you nominate a guardian, you got to do that through a will. And I'll also say this before we finish out here for today's episode. When you do a revocable trust, the surprise might be to some, you're also going to have a will. And the reason why is because what happens if you forgot an asset, or if the bank messed up and they didn't transfer your account like you asked them to, or you bought another property and you didn't put it in the trust, or if you refinanced your mortgage and you took the house out of the trust to refinance before putting it back in, but oops, we forgot to put it back in. So we do a will with trust. And when I say trust, I'm talking about revocable trusts, like I've been saying. But we do a will called a pour over will. Now, a pour over will basically says, hey, this is my will. I've got a trust, though. I set this trust up and I want it to be the distributor of my estate. So any assets that are not in my trust that should be, put them into the trust. So the will says, distribute the remainder of my estate to the trustee of my revocable trust. And so that's like a safety net, right? It's just to make sure that there's no assets that don't get distributed through the trust. So maybe we chalk one up for wills there too, because they're still needed. So maybe we're almost even on the end, but we added two, so maybe we're modifying the game a little bit. But anyway, whether it's a will or a trust, effective estate plan is essential for everyone. So I wouldn't say, well, I can't quite afford a trust yet, so I'm just going to wait until I can afford a trust. Don't wait. If you can't afford a trust, do a will. Get the power of attorney in place. Get your healthcare directive. Make sure that when you pass away, if you pass away unexpectedly, that your plan is laid out. Whether it's in a will or a trust, both are essential and better than nothing. Essential, extremely better than nothing. And so I'll say that in closing. So I appreciate you listening to today's episode. I hope that it was informative. I hope it helps you get some more clarity as to that often had debate. Should I have a will or should I have a trust? Which is better? I hope it made it a little clearer. So if you liked today's episode and you'd like to learn more, please like and subscribe for more great content. So thank you for listening to Legacy Talk. I've been your host, James Jones. We will talk to you soon. Thank you for listening.
Thank you for listening to the Legacy Talk podcast by attorney James A. Jones. If you found today's episode helpful, we ask that you like and follow us on all major platforms so you don't miss out on the latest episode. If you have questions for Attorney Jones, reach out at info@joneslegacylaw.com or visit our website at joneslegacylaw.com. Join us again next week for another episode of the Legacy Talk podcast.